Mr. Spencer, what's your email?
Joshua@joespencerlaw.com.
There it is. Okay. I'm going to email that to you.
Okay. I did talk to her though, Judge, and she appears that she has her life much more in order than when that ticket occurred or times passed.
Okay. Here, let's see here. So Carla, how long was she was supposed to start, what was it, in August or September, something like that?
Her probation date started on August 3rd, 2021.
Okay. And she just basically never showed up, right?
Correct, Judge.
And she was supposed to do how many years? 5 years?
Yes, 5 years.
Okay. Mr. Ascon, oh, okay, let's get started. Chief.
Yes, Judge. It's cause number 2020-0303328, State of Texas versus Sarah Rascon. Announcement to council, please.
Laura King for the state of Texas.
Joshua Spencer on behalf of Ms. Rascon. We are ready, Your Honor.
And Ms. Rascon is appearing from the from the jail annex. We're scheduled for a probation status hearing. We met last week. Basically, Ms. Rascon she was placed on probation, never appeared. In addition to that, in the interim, the court became aware that at least it appears there's an outstanding citation or a warrant where she was driving around October, more or less. So we have zero compliance. And Ms. Rascon, the reason I had your attorney come back after last week was because this, you basically completely blew off your agreement with the court to comply with the terms and conditions. And not only that, you were not supposed to be driving a vehicle. And here we go, you're on probation for a DWI offense and you're driving around. So why should I keep you on probation?
Because I'm ready to do good and I'm ready for that second chance, for the last chance.
So why didn't you do it the first time?
I was having problems outside with my parents.
So what's her situation, Mr. Spencer? Why are we more stable now?
She's working, Judge. She was working when she got arrested. And she's, she sobered up. So she's sober, she's working. She can take care of herself. Before, she was still using, she was homeless. She didn't have any, she went from nothing. She started probation with nothing. And it was just pretty much a setup. She just set herself up for failure. But with a little bit of time and with her own volition, she got a job. I think she's working at Pizza Hut, and now she's much better. So she has some more support, and she's away from the toxic relationship she was at before. So I think she's in a better place. I think the job is better. She's not in a bad relationship. She can afford stable housing. So she'll report. And I mean she has me as her lawyer, and we have good communication. And the good thing is that I answer phone calls, and I don't let my clients slip up as long as they call me.
So look, it concerns me very much. I'm not going to let her out until we have the monitor. Okay. I want her on a monitor. So what's her support system like? Is there someone you can work with, Mr. Spencer, to get her that monitor ASAP?
You mean like an at-home monitor, Judge?
No, it's going to be the portable monitoring unit that has GPS and daily reporting.
Well, I mean, no, I don't have contact with anybody to get it for her before she gets out. But Judge, if we give her like 5 days, I mean, she'll get it within 5 days.
Yes, I can.
That's, I'm sure, what you said last time, Ms. Rascon. I can't have you out. How is she getting to work?
My mom takes me to work. She has her own car.
Ms. King?
Your Honor, she even failed to register for VIP in the DWF classes. And
She
she
didn't,
never,
she didn't do anything.
and she does have a prior of, I believe it's a felon, I believe it was a conviction, but that's juvenile record. A burglary back in 2013 in California.
She's gonna have one week, Mr. Spencer, to get that monitor. She's going to report, who's her probation officer, Miss Pineda?
Her name is Maribel Gonzalez.
Maribel Gonzalez. I'm gonna go ahead and allow her to be released. Is there I would imagine there's an MTA, an MTR filed?
Yes, Your Honor, it was filed on October 29, 2021.
Mhm. And so I'm gonna allow her to be released. The motion is gonna remain pending. She's going to have 1 week from today to acquire that monitor. She is to report immediately upon release to her probation officer. We'll be coming back on Tuesday, Mr. Spencer, at 10 a.m. If she doesn't have an answer, meaning have her monitor reported to her probation officer by Monday, then I anticipate revoking her. Plain and simple. The conditions will remain unchanged for now, so continued no driving, things of that nature. And she must appear via Zoom at the hearing next week. Okay?
Very good, Judge. Did you understand that, Sarah?
Yes, ma'am. Yes, sir.
Thank
All
you,
right.
Judge.
Thank you. Who's next, Chewy?
Okay, Judge, let me see if Mr. Islas is here.
Mm-hmm.
Annex, if we can get Isaac Gonzalez, please. Isaac Gonzalez.
I'm here.
Hello, Mr. Islas.
Yes, sir,
Hello,
we're calling
Judge.
up your client, sir.
All right, go ahead, Chewy.
Yes, Judge. Cause number 2021-0D02891. Cause number 2021-0D02889. State of Texas versus Isaac Gonzalez. Announcement to council, please.
No.
Roa King for the state of Texas.
Luis Islas for Isaac Gonzalez. Your Honor, I believe the
Yes, that was
cause number is 2021-0D02890, not 91.
I think that's what I'm showing too. Am I missing a case here?
No, what,
No.
Judge, I see he's listed under two different cases.
Yeah,
2889 and 2890, I believe.
that's correct. That's correct. Mhm. And both of those are set for bond hearings. Mr. Gonzalez is appearing from the jail annex. Mr. Islas, you may proceed.
Thank you, Your Honor. We're asking you to consider a PR bond. I believe Mr. Gonzalez was on a PR bond that got revoked on the 2889 case. If released, he would reside with his common law wife, Sarah Briggs, at 4604 Hercules. That's the Athens Gate Apartments, apartment number 180. Ms. Briggs' phone number is 915-505-2377. And he has a job prospect working with Mike Garcia Security. That's basically all, Your Honor. We've got our settings in both cases.
Okay, so these cases arise out of the same incident, correct?
No, one is July 11th of 2021, and the 2890 indictment is, I believe, September 11th, 2821.
Okay, and he's been in jail for a while. Okay, Ms. King, go ahead.
Yeah, Your Honor. So we did have a P file. However, that was dismissed on December 21, 2021. For two reasons. One of the reasons is number 19, which is used as extraneous. And it was also for possession PG3. So we're still having the same, even though it was dismissed. I believe we're going back to the same. There's the issue of using.
Right, same type of conduct. Okay, what in terms of, so the sole basis for, was the rearrest? Was he on any kind of PR bond, or is it just he was on a PR bond, so was it just a rearrest? Or was it other issues with PR bond?
It was a rearrest on the 2890 case, I believe. I'm not certain, Your Honor.
Can you see that, Mr. House or Miss, I don't know if Miss Nieto's still here. On the PR revo.
It was a failure to appear for Takumi.
Oh, okay. Okay.
And also a never reporting.
Oh, well, there we go. Thank you, Mr. House. Give me a second. So what are his bonds right now?
I believe that there are $20,000 on, I think, the 2889 case, and 18,000 on the 2890 case, cash or surety, both.
Mr. House, can you confirm that, please?
Yes, Judge, that is correct.
Okay, so 20,000 and 18,000. Yeah. Yeah. I think those are appropriate, Mr. Islas. So the request for bond reduction is denied.
Thank you for your time, Your Honor.
Thank you, Mr. Islas.
May I be excused?
You may. Thank you, Mr. Gonzalez. Who's next, Chuy?
Okay, Judge Rubalcaba on page 8. Downtown, if we can get Mr. Rubalcaba, please.
I'm here, Judge.
Have a seat, sir.
Okay, Judge.
All right, go ahead.
Clause number 2018-0D03021, State of Texas versus Javier Adrian Rubalcaba. Announcement of council, please.
Roa King for the state of Texas.
Omar Carmona for Mr. Rubalcaba. Your Honor, I think we discussed this morning our issues in communicating with Mr. Rubalcaba with his COVID quarantine. If possible, I don't know what kind of docket you have, but if I can wait to get a breakout room later to discuss what you had indicated to me, what you were thinking your options were.
Okay, well, the good thing is I think he's at the downtown jail. So Chuy, can we put them in a breakout room and go back to the annex?
Yes, Judge, I'll do that.
Yeah, okay. So let's go ahead and try that. Just if you'll come back, Mr. Carmona.
Yes, ma'am.
All right.
I'm gonna open up the breakout room. Give me a second, Mr. Carmona.
Thank you.
And then Annex, if we can, does Annex, do you have Justin Walker? And Ms. Caballero, are you there?
I'm here, Your Honor.
Great, great. Thank you. Thank you. If we have your client, we'll go ahead and do yours next.
Perfect.
Okay, Judge, they should be in the breakout room.
Okay.
Walker.
I was asking for Mr. Walker,
Yes, ma'am.
All right, Mr. Walker, this is Judge Perez. I understand we're scheduled for a plea today. I'm not displaying my video only because my internet is unstable and I am working remotely. Ms. Caballero, are you okay to proceed on the plea without me being on video?
Of course.
Okay, all right, then let's go ahead and get started, Chewy.
Yes, Judge. It's cause number 2021-0D0-2593, State of Texas versus Justin Davis Walker. Announcement of council, please.
Roa King for the state of Texas.
Teresa Caballero on behalf of Mr. Walker, we're ready.
And Ms. Caballero, you see your client appearing from the jail annex?
Yes, I do.
Mr. Walker, this is Judge Perez. As I mentioned, sometimes the internet can get a little crazy and the audio sometimes is not very good. What I would ask is if at any point you cannot hear me or the attorneys clearly, please raise your hand. I can see you. So if you'll please raise your hand, I'll go back and repeat anything you don't hear, okay?
Okay, thank you.
All righty, let's get started. Sir, would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes,
Okay, you can put your hand down. Would you state your name for the record?
Justin Davis Walker.
Mr. Walker, as I mentioned, we're scheduled for a plea today. It means I'm going to be asking you about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Walker, do you recall reviewing State's Exhibit number 1, the plea papers, with your attorney and signing that document?
Yes, ma'am.
And did you understand everything contained within that document?
Yes, ma'am.
Ms. Caballero, have you had 10 days to prepare a defense in this case?
I have.
And did you explain the plea papers to your client?
Yes, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
I do.
Mr. Walker, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Ms. Caballero, do you have any reason to believe your client is not presently competent to enter a plea?
No, Your Honor.
Mr. Walker, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am. Yes.
Yes? Was that
No.
a yes? I'm sorry, you just got muted. And I don't know who muted you. Mr. Walker, I'm sorry. Have you ever been examined by a doctor or psychiatrist who has ever found you mentally ill?
No, ma'am.
Okay, perfect. So based on your testimony, your attorney's representations, and my observations of you, I will find that you are competent to enter your plea today. Mr. Walker, are you a U.S. citizen?
Yes, I am.
Where were you born?
Las Vegas, Nevada.
Okay. And so the charge against you in this case is credit card or debit card abuse. To that charge, sir, what is your plea? Guilty or not guilty?
I'm guilty. Yes, you
Are you making your plea freely and voluntarily?
Yes.
We'll find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charged, credit card or debit card abuse beyond a reasonable doubt. At this time, the state moves to admit Exhibit 1 as the state plea paperwork, Exhibit 2, Article 3914 disclosures, and Exhibit 3 as the indictment. Judge, the defendant is pleading to a 1244B for 132 days of confinement with credit for time served.
Okay, Ms. Caballero, any objection to State's Exhibits 1, 2, and 3?
None.
And is that your understanding of the plea agreement?
It is.
Okay, the State's Exhibits 1, 2, and 3 are admitted. Mr. Walker, is that also your understanding of the plea agreement?
Yes, it is.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled Your Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Walker, do you recall reviewing that document with your attorney and signing it as well?
Yes, I do.
Okay. It was signed by your attorney and signed by the court. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of credit card or debit card abuse, and I will sentence you according to the plea agreement and in accordance with 1244B of the Texas Penal Code to 132 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. Is there anything further, Ms. Caballero or Ms. King?
Nothing further from the state, Your Honor.
No, Your Honor. And just if I could ask the court, if the court could sign an order of releasing him, he should be finished with his sentence. He pled guilty to the misdemeanors. I think it was on Friday.
Okay.
And we really want to get out of jail ASAP.
I will tell you this, Ms. Cabero, although I received them as we're going through the docket this afternoon, I think there's Marissa's better at explaining this. I think when we get it back to them, I don't know if the jail folks process it as quickly as we get it to them, just because it's the end of their day. But as soon as I get it, I'll sign off on it and send it back. Okay.
Thank you. Thank you, ladies. Bye-bye. Bye-bye, Mr. Walker. Good luck to you, Mr. Walker.
Thank you. Appreciate it very much.
Sure. Bye-bye.
Hey, Judge, Mr. Carmona and Mr. Rubalcaba have returned to the Zoom meeting.
Okay. Mr. Carmona?
Yes, Your Honor.
Okay, so we were set for a bond hearing. Did you want, you'll just have to refresh my memory. Are we going on the bond hearing or?
Well, we would, Your Honor, but I mean, I'm assuming, do you have someone from probation today, Your Honor?
We do.
I mean, I guess if we could just ask, you know, how's he been doing on probation? If there's anything we can try to rectify to get Mr. Rubalcaba all squared away.
Okay. Let me see. Let me go back to my reports. So, okay, so yeah, it was BHRTC. Yes, I'm afraid I'm not anywhere but BHRTC. So I hope that answers your question, Mr. Carmona.
So it's BHRTC, okay, or we're possibly moving on to revocation.
Correct.
Then if I may, Your Honor, just have a week reset to talk to him, Your Honor, about that, given, because I guess I would know where that bond hearing is going to go, so I can get a chance to explain to him what's going on, and I can have an answer for the court right away.
Okay, we'll reset you for 1 week.
Thank you, Judge.
Thank you. Thank you, downtown. I think that's everyone. Please stay healthy.
Thank you, Your Honor. May I be excused?
Yes, thank you.
Thank you.
Thanks, partner. Annex, if we could get Villanueva, please. Rafael Villanueva. Okay, ready, Judge.
Okay, go ahead.
Yes, ma'am. It's cause number 2020-0D04363. Cause number 2020-0D06556. State of Texas versus Rafael Villanueva. Announcement of council, please.
Robert King for the state of Texas.
Mr. Villanueva?
Yeah, I'm right here.
Okay. Well, wait a minute. So let me, I was expecting an announcement from you, Mr. Villanueva, but I guess that's part of the issue why we're here, right? We're here for a motion to withdraw that it was actually filed by Mr. Williams. Mr. Williams, are you the attorney of record?
I'm not judge. I'm the advisory counsel. Mr. Villanueva had asked me to file. I know technically since he's the counsel, he should file kind of with all the issues around COVID. And even though I've been vaccinated and boosted and I had COVID, I got COVID again. And I just thought it would be easier to file it myself than to go to the annex to talk to Mr. Villanueva to make sure that he filed it.
So, Mr. Villanueva, your attorney of record, are you ready to proceed today?
That's not what I was told by the district clerk and the public defender's office. That it's still showing that Mr. Williams has been the attorney of record since September as lead attorney, and I had spoken to Mr. Williams in October, and I told him if I had to remain incarcerated, that I would be requesting counsel to represent me. Now, since our conversation, it's been under both of our understandings that he has been lead counsel in since I believe October. So we had a discussion in December of.
Well, before you tell me, Mr. Villanueva, hold on. Before you tell me any of that, are you asking that you continue to represent yourself in this court, or are you asking that Mr. Williams represent you or an attorney represent you because you are incarcerated?
Right. I mean, well, because of the issues with the law library, they have there's no way that I would be able to satisfactorily represent myself.
Okay, so Mr. Villanueva, I just need to be clear. Are you asking that you have an attorney represent you?
I am asking for an attorney to be appointed in a co-counsel role, and we could proceed to trial with the hybrid representation.
So as Mr. Williams,
Right, another attorney, I'm sorry, not Mr. Williams. Me and Mr. Williams have had issues from that have stemmed from what I just stated.
Okay.
I don't think Mr. Williams has an interest to represent me going to trial.
Okay, so hold on. I don't want to know the substance of I guess some of your conversations. This is what I need to know though, Mr. Villanueva. Okay, you had previously asked the court to represent yourself. And
right.
The court had granted that request, and later we rescinded or transferred you to another court. Now that you're back here, I guess I want to know, are you asking to continue to represent yourself, or are you asking for an attorney, maybe not Mr. Williams, asking for an attorney to represent you?
Right, yes, in a hybrid representation.
What do you envision with hybrid? Like you have an attorney appointed as co-counsel to you?
Right, so that way he can file motions, and I would have the liberty of also filing motions, and I would be the one who would actually present my defense at trial.
If your intention is to continue to represent yourself, then I will only appoint an attorney who can advise you, and the responsibility will be yours to represent yourself.
That won't be possible, because there's a lot of information that is outdated at the law library, and I needed an attorney to file the motions from here to trial with current updated information regarding everything with COVID that I don't have access to. So that's the only reason I'm asking for co-counsel to be appointed, and then going forward to trial, I would actually make my presentation. It is nearly impossible for me to represent myself with information that has been outdated. Yeah, it's outdated in the law library. It's not feasibly possible for me to do that from here till trial.
Give me 1 second, Mr. Villanueva. Mr. Williams, the motion that you filed, can you, because I am working remotely, I don't access Odyssey. What is the basis of that motion? Is it simply just to go back to the status quo where Mr. Villanueva was representing himself, or was there some other issue?
He's asked me to withdraw, Judge, so that's why I filed it. My understanding, though, was that I was appointed to be lead counsel only in the 384th when there was issues regarding his competency. And there was, we were asking for a competency hearing, and so they named me the lead counsel regarding competency only. But my understanding was that I'm actually, in this court, just advisory counsel. So my motion actually was filed as appointed advisory counsel for defendant. And
and so you're asking to withdraw in that capacity from that?
Yes, Your Honor.
Okay. All righty. So again, Mr. Villanueva, if what you're asking is to continue to represent yourself, I don't know that it doesn't sound to me like what you're saying is that you feel you have the resources to be able to adequately do that. And so for that reason, I'm not gonna, because you are incarcerated, I know we've reviewed the bond, that's not changing. So I am going to appoint you an attorney to represent you.
Right, with hybrid, in a hybrid representation capacity.
No, that's not what I'm going to do. I am going to appoint an attorney to represent you. Now, if at some point that representation is not how you are wanting to proceed, or if there is an issue, then you can bring it to the court's attention. But
I would be okay with that, as long as once we get to trial, he would be able to withdraw so I can make my presentation at trial.
That's not an agreement I am going to make with you right now, but what I will do is I am going to appoint you an attorney, because I can imagine, when is our trial date?
May 20th, Judge.
May 20th. Okay. And we're here also, we're not just here on the motion to withdraw, we're here at the pretrial 2801 motions hearing. So technically this is the deadline by which you would be having to file motions.
I'm willing to waive the deadline because I'm fully prepared to go to trial. I've been prepared for over 8 months, and I've now been here for 14 months. And the only thing that has caused a delay would have been the thing with the pandemic and the coronavirus. So
here's what I'm going to do. What is our next setting, Chris?
March 1st, Judge.
March 1st.
Status conference at 3 p.m.
Okay.
That'll work for me.
Okay, so what we're going to do is, number one, I'm going to grant Mr. Williams' request, because it sounds like you're in agreement, Mr. Villanueva. Am I correct on that, to withdraw?
Oh, most definitely.
Okay, so Mr. Williams, thank you for your assistance to the court, but I am granting your motion to withdraw. I am now going to appoint the public defender's office to represent Mr. Villanueva. So we will send that order appointing. I know we have a representative here, but I don't know if within that office, if your case will be assigned to her or to someone else. And so we'll come back next week.
No, I can waive the deadline for the 2801's motion.
No, you can't waive it.
Yeah.
That's the court's deadline.
I'm in here in a pro se capacity today, so I think I can make the decision.
So that's the court's deadline. It's not your deadline. So we're understanding one another. But what I will do is I'm going to extend the 2801 deadline to our next setting, which is March 1st, so that after you consult with your attorney, if there are motions that need to be filed, they are filed within the deadline. You
There
shake
are
your head no, but clearly that indicates to me, Mr. Villanueva, that you don't understand what that means.
I do know what that means. I don't,
2801 motions, excuse me.
there are no motions.
2801 motions are motions that you may need to file in your defense.
I'm fully prepared to go to trial. I'm letting everybody know that there are no more motions to be filed.
So I am going to extend the 2801 deadline till March 1st. You are going to be appointed the public defender's office. We will be back in 1 week on a status. And Mr. Villanueva just walked away. That's the order of the court. Mr. Williams, if there was an order on your motion to withdraw, if you'll please send it on over so I can sign it. And Chris, we need to get those orders appointing ASAP to the public defender's office.
Will do, Judge. Thank you.
Thank
Thank
you,
you,
very
Judge. Have a great day.
too.
Can I be excused?
Yes, sir. Please
Thank you.
take care of yourself, Mr. Williams. No more.
Thank you,
calls.
Judge.
All right.
And we're done with Mr. Villanueva. He can be taken back. If we could get Refugio Rios, please.
Yes, sir.
Getting so many messages. Mr. Rios. Okay, and there's Miss Butterworth. Okay, let's do it, please.
Yes, Judge.
All right.
Cause number 2016-0D04953. Cause number 2021-0D01591. State of Texas versus Refugio Rios Jr. Announcement to council, please.
Roa King for the state of Texas.
And good afternoon, Your Honor. Denise Butterworth on behalf of Mr. Rios, and we are ready to proceed.
And we're scheduled for a plea today. As I was mentioning, I don't know if you were on, Miss Butterworth, but I am not putting my video on because I'm operating remotely and my computer is just not able to handle things. Are you okay? Are you and your client okay proceeding without the video?
Yes, Your Honor.
Okay. And do you see your client appearing from the jail annex?
I do. I recognize him.
Okay, Mr. Rios, this is Judge Perez. I understand just as to cause number 1591, we're scheduled for a plea. So I'm going to need to ask you some questions. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
I do, Your Honor.
You may put your hand down and please state your name for the record.
Refugio Rios Jr.
Okay, Mr. Rios, I'm going to be asking you about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Rios, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Your Honor.
And did you understand everything contained within that document?
Yes, Your Honor.
Ms. Butterworth, have you had more than 10 days to prepare a defense in this case?
We have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
I do.
Mr. Rios, are you satisfied with your attorney's representation of you?
Yes.
Ms. Butterworth, thank you. Ms. Butterworth, do you have any reason to believe your client is not presently competent to enter a plea?
I do not, Judge.
Mr. Rios, have you ever been found incompetent by any court?
No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, Your Honor.
Okay, where were you born?
Here in Paso, Texas.
Okay, so in this case, there are 4 counts. You're originally charged with 2 counts of aggravated kidnapping with a deadly weapon, and then 2 counts of aggravated assault with a deadly weapon. I understand through negotiations you were pleading in all of those counts to lesser included offenses. As to count 1 and 2, it is the misdemeanor offense of unlawful restraint. Is to count 1 unlawful restraint, what is your plea? Guilty or not guilty?
Guilty.
As to count 2, unlawful restraint, guilty or not guilty?
Guilty.
Now, as to counts 3 and 4, the lesser included offenses there are Class A misdemeanor assaults. So count 3 assault, plea is guilty or not guilty?
Guilty.
And count 4, what is your plea?
Guilty.
Okay, are you making each of these pleas freely and voluntarily?
Yes, Your Honor.
Okay, I will find you are making your pleas freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of each count. Count 1 and 2 as aggravated kidnapping with a deadly weapon. Count 3 and 4 aggravated assault with a deadly weapon beyond a reasonable count. However, at this time, the state has agreed to a count 1 and 2 to a lesser included offense of unlawful restraint. Count 3 and 4 for a lesser included for an assault causes bodily injury for 188 days confinement. Further, the defendant is to be modified into BHRTC in cause number 2016 0D04953 and dismiss cause number 2021 0D01590. At this time, the state moves to admit Exhibit 1 as the state's plea paperwork, Exhibit 2 is Article 3914 disclosure, and Exhibit 3 as the indictment.
Any objection?
No objection, Your Honor.
States Exhibits 1, 2, and 3 are admitted. And Ms. Butterworth, is that your understanding of the plea agreement?
It is, Your Honor. And I'm not sure if Ms. King said in her summary that we are modifying my client on his probation case on the 2016. Did you mention that, Ms. King?
She did.
Yes, I did.
Okay. Yes, that's our agreement, Judge.
Okay. And Mr. Rios, is that your understanding as well?
Yes, ma'am.
Okay, I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the trial court certification of your right to appeal. It is a document that explains your appeal rights. Because this is a plea bargain or negotiated case, you do not have an automatic right of appeal. Mr. Rios, do you recall reviewing the trial court certification with your attorney and signing that as well?
Yes, Your Honor.
Okay. Signed by your attorney and signed by the court. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of 2 counts of unlawful restraint and of 2 counts of assault causing bodily injury, all Class A misdemeanors. And I will sentence you according to the plea agreement to 188 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. I do also show a dismissal. I'm not sure in cause number 2021 0D01590.
It was
already
dismissed before the plea agreement.
Okay, so that one's already done. And then of course, as to cause number 2016 0D04953, that is your probation case that will be modified for your placement in BHRTC. Is there anything further, Ms. Butterworth or Ms. King?
Nothing further from the state, Your Honor.
Nothing further from the defense, Your Honor. Thank you.
Good luck. Thank you. Good luck, Mr. Rios. Yes, ma'am.
If the court would please address Mr. Rios's probation case of 2016, we do need an extension. I know we've discussed this in the
Oh, that's right. That's right, right. As to cause number 2016 0D04953, the additional issue with his placement into BHRTC was that the court will be extending him for 1 year for Mr. Rios to complete treatment and aftercare. That time, although it's not unlimited, does take a little bit of time, and it's not, how can I say, it's not certain. So it may be a month or 2. As I explained to your attorney, Mr. Rios, if you complete BHRTC successfully, which means the additional aftercare, we might be just under a year. And if so, then if you need to address the court for whatever reason, you may do so, but it will just depend on the circumstances, okay?
Yes, ma'am.
All right, thank you very much. Anything else? Thank you, Carla.
Yes, ma'am.
All righty, then we're good to go. Thank you, Mr. Rios.
Thank you, everyone.
Take care. Who's next, Shui?
Agosto, page 6, Judge. Annex, if we could get Ismael Agosto, please.
Yes, sir.
All right, go ahead. Oh, Mr. Ortiz, are you there?
Yes, Your Honor. Sorry about that.
You're always so busy. All right, we're good to go on. It's Mr. Augusto. Go ahead, Chief.
Yes, Judge. It's cause number 2021-0D03089, State of Texas versus Ismael Angel Agosto. Announcement of council, please.
Samantha Rock on behalf of the state. State's ready, Your Honor.
Good afternoon, Your Honor. Ruben Ortiz on behalf of Mr. Ismael Agosto. Your Honor, on this case, we requested a bond reduction hearing, Judge. I'm not sure if that's why, I'm hoping that that's why we're.
Yes, we're here for a bond hearing. Mr. Augusto is appearing from the jail annex. You may proceed, Mr. Ortiz.
Okay, great. So Your Honor, my client is, let me see, about 21 years, he's 21 years old, Your Honor. He's single, Your Honor. His current job before he was arrested was working as an Apple sales representative, Your Honor. Before he was arrested. He would be, if he were to be given a reasonable bond, Your Honor, because right now it's really outside of the range.
What is it, Mr. Ortiz? What's the bond?
Let me look.
Your Honor, it's 1.3 million.
Okay.
Yeah, it's very affordable, as you can see, Your Honor. Anyhow, it's set very high, and I understand why it was originally set that high, Your Honor. It's the facts are not that good. However, Judge, my client, I'm trying to see what kind of criminal record he has. What he has, Your Honor, is he has some manufacturing delivery cases against him. He was out on bond on those cases, then he picked this case up, Your Honor. I can tell you, Your Honor, that he cannot afford $1.3 million, Your Honor. The recommendation is 15 TDC. He is a United States citizen. His ties are to El Paso. I don't believe he has any convictions whatsoever. He would be residing with his mother and his mother, and he also has a pending job if he was allowed to working in Odessa with the Ruben Munoz, Your Honor.
What resources?
He's willing to abide by whatever conditions of PR bond, Your Honor. However, we are requesting something that's reduced because it is a little excessive, Your Honor.
Mr. Ortiz, what resources does he have for a bond?
Your Honor, I think his family might be able to come up with, like, if it gets reduced to some type of 25,000 or 50,000 even, they might be able to maybe work around that for the bond, Your Honor. And I'm talking about that way they can go to a bonding company and get maybe 10% of that.
Okay. All right. Anything else?
Nothing further, Your Honor.
Okay. Ms. Rocco?
Yes, Your Honor, the state respectfully opposes a reduction. Based on the facts of the case, there's 4 victims. One of the victims was shot in the cheek and on the foot and was in ICU with it. At this time, we're requesting the medical records to receive it. The second victim, a bullet grazed the back of her right knee. In addition, there was 2 other victims that the gun was held toward them as well. And for those reasons, we're concerned for the safety of the community. We've had contact with one of the victims' parents. They were around. Some were 18, some were younger than 18. So we're in the process of trying to contact the victims. In addition to that, he doesn't have criminal history. He was placed on a bond, and this was for a Mandel controlled substance, PG2, more than or equal to 4 grams and less than 400 grams. That was for a THC vape card. And then in addition, there was another charge, which is a Mandel out of the same incident, that was controlled substance, PG2, more than 4 grams, less than 400 grams. And that was for THC moon rocks, Your Honor.
Well, I'm sorry, I need a little more context because it's not often that I see bond that high. I'm imagining that's coming from JMAG, right? So
That's
what happened.
So officers were dispatched for an ag assault. There was shots fired. There was 3 casings that were found. Victim 1 was shot in the cheek. Victim 2, the back of the knee. My understanding, there was a witness that said that they were coming from the defendant's cousin's house that was around Cincinnati, came out of the car, and that's when he pulled out the gun and was shooting at those individuals.
Are there co-defendants?
My understanding, there isn't, Your Honor.
Actually, Judge, I think there are co-defendants. I believe that there's at least, there was, my investigation, I'm going off of my investigation, Judge, is that, and let me read my notes real quick. My investigation, Your Honor, is that the shooting, Your Honor, or the shots were fired from a vehicle, Your Honor, and there was more than one person in that vehicle, Your Honor. And the allegation is that my client was in that vehicle. Therefore, there should have been some co-defendants, Your Honor, in this case.
Okay, but as we stand right now, nobody else got picked up for this, right? Just the defendant.
My understanding, Your Honor, under involved persons, it doesn't show any other co-defendants.
All right.
Stop, please. For advertisement.
I'm sorry?
Today's best mix. 93.1, the radio.
Was that? Oh, someone's got the radio. You know what? I use it as background noise, so I don't get. Hold on, let me turn that down. Hold on.
So
I don't even listen to the music. I just put it as background noise.
State as opposed to any, I mean, what are the concerns you have? What's, I mean, he's been in El Paso all his life, or what's going on?
Yes, Your Honor.
Your Honor, state's concern, there was gang signs that were thrown, and then also concerns for the victims as well with it, just for safety of them.
Do they know each other?
I don't believe so, Your Honor.
All right. Okay, so for now, I'm gonna go ahead and reduce the bond some, Mr. Ortiz, I don't know that it'll be.
Okay, Judge, you're breaking up. I'm hearing you saying reduce bonds. Can you try again, please?
I don't know that it will be what the defense is contemplating. I'm just gonna reduce it. It'll be a $1 million bond, $750,000 cash surety, $250,000 PR, report weekly, possess no weapons or ammunition, use no illegal drug or alcohol. He's to maintain his residence, I believe you said, with mother. He may not leave El Paso County, so for no purpose, no working, none of that. May not change his place of residence. He may not have any contact or come within 200 yards of any of the complainants or their families. My understanding is this happens at Cincinnati, the Cincinnati district. Is that right?
That is correct, Your Honor.
Yes,
okay,
Your Honor.
so he can't be within 200 yards of the Cincinnati Entertainment District. He's not to go into any bars or any of those types of establishments. I think that's it for now. Mr. Ortiz, if you need to come back on a future bond hearing, just send us your request and we'll get you scheduled, okay?
Thank you, Your Honor.
Thank you. All right, who's next, Chewy?
May I be excused?
Yes, sir. Thank you very much.
Thank you.
May I be excused, Your Honor?
You may. Thank you.
Thank you.
Bye, everyone.
Bye.
On Zoom world.
Annex, if we can get Salvador Sapien, please. Salvador Sapien.
Yes, sir.
Thank you, Brendan.
Look at the plea. Oh, mira nomás this little plea sitting here. Okay.
Ms. Martin, is he a Spanish speaker?
No, he's not.
Okay.
Ready to go.
Yes, Judge. It's cause number 2021-0D01406, State of Texas versus Salvador Sapien. Announcement of council, please.
Roa King for the state of Texas.
Julia Martin on behalf of Mr. Sapian, ready to proceed, Your Honor.
And Ms. Martin, do you see your client appearing from the jail annex?
Yes, Your Honor, I do.
Okay, Mr. Sapien, this is Judge Perez. Can you hear me okay?
Yes, ma'am.
Okay, so sometimes I don't have my video on because my internet is not the best right now. But if at some point you can't hear me, or if you have trouble hearing the attorneys, please just let us know, wave your hand, do something so we can go back and repeat anything that you do not hear, okay?
Yes, ma'am.
Okay, so let's get started. Sir, I'm going to be asking you questions, so I need to swear you in. If you would raise your right hand as best as you can. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you. You can put your hand down. Sir, would you state your name for the record?
Salvador Sapien Jr.
Okay, sir, I'm going to be asking you about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Sapien, do you recall reviewing State's Exhibit Number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Ms. Martin, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor, we have.
And did you explain the plea papers to your client?
Yes, Your Honor, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering a plea today?
Yes, Your Honor, he does.
Mr. Sapien, are you satisfied with your attorney's representation of you?
Yes, ma'am. Very.
And Ms. Martin, do you have any reason to believe your client is not presently competent to enter a plea?
Absolutely none, Your Honor. He's competent.
Mr. Sapien, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Torrance, California.
Okay, so the charge against you is burglary, I guess, let me see. Was it just one count of burglary of building, Ms. King? Yes?
Yes, Your Honor.
Okay, the charge is burglary of building, sir. To that charge, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, ma'am.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charged, burglary of a building beyond a reasonable doubt. At this time, Your Honor, the defendant is pleading to a state jail felony 1244A for 200 days confinement and to dismiss cause number 2021-0D01967. At this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosures, and Exhibit 3 is the indictment.
Any objection, Ms. Martin?
No objection, Your Honor.
And is that your understanding of the plea agreement?
Yes, Your Honor. He's also going to be time served on a criminal trespass. And I'm awaiting a setting on that plea date so that Mr. Sapien knows why he would not be able to get out today.
Okay, Mr. Sapien, is that your understanding as well?
Yes, ma'am.
Okay, I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is a one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Sapien, do you recall reviewing that document with your attorney and signing it?
Yes, ma'am.
It was signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of burglary of building, and I will sentence you according to the plea agreement and in accordance with 1244A of the Texas Penal Code to 200 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. I understand also that once I receive the dismissal, I will sign it for cause number 2021-0D01967. As your attorney mentioned, Mr. Sapien, the misdemeanor is still outstanding. So although your matters in this court will be resolved, there's still a pending misdemeanor matter. So you may be in jail just a little bit longer, okay?
It doesn't say when I would have court for that.
They still have not given me a date, Mr. Sapian. I'm still waiting on it. I did send all the paperwork in last Tuesday.
Okay, thank you.
And for the case, I mean, he is time served. It's 200 and as of docket time, he had 215 days. So with us, you're good to go. Ms. Martin, Monday.
I'm so sorry. Just for clarification, this was for count 2, right?
So that's what I was asking. I wasn't sure if on the docket, if there were 2 counts or just 1.
So I see a count for ACPR rebel burglary of building, and then
Yeah, so that's not, I think the ACPR rebel is probably what got him in jail, but it's not a separate count. Just 1 count. Am I right on that?
Your Honor, this is Marissa. It's a 2-count indictment. I'm looking at the indictment right now. It's just listed ACPR revo incorrectly, but we will change the code to what it's supposed to be, which is burglary of building. We're just not sure as to which count he is pleading. It's not stated on the plea paperwork.
So will you all take a look at that? Is it safe to
Well,
say
when we
count
first
1?
came, I do remember that we thought it was something else, you know, that it wasn't a separate count. But I mean, obviously it was.
So we never had I mean, if it's showing 2 counts and if that is still the agreement, then I would just say pick a count, guys, and then get me a dismissal on the not chosen count. And I apologize. I just don't have Odyssey in front of me.
Miss King, is it okay if I put in the information for count 2, burglary of building, and then you can do the dismissal for ACPR rebel?
Absolutely, that works.
Okay, so just get me that dismissal. All righty.
Thank you.
Thank you all. Thank you,
It
Mr.
said
House.
AC Revo, so I thought it was something else.
Yeah. All righty.
Thank you.
All
Your
right.
Honor.
In any event, we're still good to go, Mr. Sapien. All righty.
Thank you.
All right.